Let's move forward. Our next piece here, a federation fit for the future, of course, was the one we just heard, as if I wasn't on the wrong page. The DG, you can talk about that, Ben, if you like. You just do McCann's speech again. Why not? The DG6 campaign, the campaign update, really, on this. Ben Hudson, as many of you will know, National Detectives Forum Chair, Branch Secretary over there at Suffolk Police Federation. We're also going to be joined shortly by Chief Constable Tim Meyer as well. I guess worth saying, Ben, and we've talked about this for a few years now. DG6, give us the overview. Everyone in this room will be familiar. What is the latest, what's the update, and what are you trying to achieve?
So since August 22, we've been looking to have the objectives of appealing to the government to make amendments to the data protection laws to simplify the redaction obligation on all of you, and calling for the MPCC, College of Policing and the CPS to work jointly with the Federation to ensure all its members receive nationally agreed face-to-face training on disclosure. Through the Federation, we, on the legal advice that we obtained, we've looked to change the law on your behalf to give you a legal exemption under the Data Protection Act or under the various guises, but the latest one was the Data Access and Use Bill, to ensure that you had that legal exemption from falling foul of data protection rules, because you could then pass material unredacted to the CPS pre-charge. We had an early success in the House of Lords, where it was tabled, but sadly the government wouldn't support it there. And then when the bill moved to the House of Commons earlier this year, we couldn't get any of the MPs to sadly support it, which is really disappointing because the legal basis of what we've pitched is sound. The response from the government lawyers has always been, well, it would be in contrary to common law and the Human Rights Act, but that argument is unfounded in my view, because we wouldn't be able to send anything to anyone ever, and as we all know, every single day we send a multitude of unredacted data across the country to various police forces, to social services, to all our colleagues we work, our stakeholders, simply because years ago or over the years they've written the exemptions and the annexes into the Act. So we move forward. I'm really optimistic about loads of the recommendations of the Disclosure in a Digital Age report, an independent review of disclosure and fraud, which was published in March 25. Jonathan Fisher-Casey has done a root and branch review of disclosure and fraud right through from policing through to the judiciary. There's some really promising recommendations in that. And as your lead on this, I'll be working with all the stakeholders on this to try and see if we can get some of those recommendations moved, because speaking to colleagues last night in the focus group, and I'm grateful for you all for the comments you made, when you hear anecdotes of colleagues finding other colleagues crying in toilets because they're so stressed they can't cope with the disclosure or the amount of work they're having to put in just to get a case. When we're hearing of colleagues talking about it taking them up to 2 years to get a single rape trial case ready to send to the CPS for trial, which they then may take 6 months, a year to review, this is not swift and effective justice for victims. You know, this is not what we should be doing, and this is not what I was listening to the colleagues say last night they want to do. They don't want to be witnessing colleagues leaving custody blocks in the early hours of the morning crying because they're trying to get a person remanded, and they're having to let them go with all the risks that takes because they simply don't have enough time in the pace clock to get the material ready to send to the CPS. But I am very, very grateful for all of the support and collaborative work that Mr. Meyer has done and his portfolio under disclosure. We've been on this journey together. No one has gripped this matter like Tim. He really has been a warrior in this, and I know that, and that's why I'm so pleased he's talking to us today, because there has been improvements. There will be improvements. It's not going to be the legislative change I wanted, but that we are. But what I do know is that we will continue this journey together, and promising changes for the better will come.
Good. Let's bring in Tim, Chief Constable Tim de Meyer. Afternoon to you, Tim.
Good afternoon, and thank you very much for the invitation to address such an important audience.
Indeed. It's interesting that Ben talked about the support you've given to this, and you understand and recognise the frustrations. It's gone on for some time, difficulties in the Houses of Parliament, in both houses, trying to get full recognition of this. Does your view, and we'll come on to more details about where you're at on this, but are you kind of supported by other chiefs in this area, or are you a bit of a lone voice?
Well, quite the opposite, in fact. I mean, they hold me very keenly to task for the two reasons set out by Ben. One is that the police are obviously there to deliver justice to the victim, but even more fundamentally, we're there to uphold the absolute right to a fair trial. We're there to deliver swift and certain justice, which kind of fights crime and protects people. And we're not going to do that when the system is so slowed down as it has been in recent years. And that's a great source of frustration to other chief constables who see public service and crime performance suffer, and therefore have been at times, I'd imagine, quite exasperated by the state of affairs and anxious we do what we can to fix it. But also, of course, we're acutely aware of the extremely bad effect it has on the well-being of investigators. We want that extra capacity created, not only because we want to bring criminals more swiftly and fairly to justice, but because we want to relieve those burdensome caseloads which discourage people from taking on investigative roles, which discourage people from becoming detectives, and which leave people with this sense of not being able to realise the meaning and the purpose that they joined the police to do. So it is very much for me in the criminal justice portfolio to get on with the technical side of addressing things, but there isn't a chief constable out there who doesn't share the frustration of this in particular. And I hopefully can I feel whenever I've appeared for audience such as this, I've been expressing optimism for 6 years now, so maybe I should learn from that. But at some point, there is going to be more progress, and we have got some progress to report. So perhaps I could have the indulgence of talking about a bit of that.
Indeed. Well, do go ahead, Tim, on that progress. I think there's a...
Well, I'll press on. So Ben's mentioned the independent review of disclosure, a weighty report from a distinguished KC, and we do hope that's going to go some way to stimulating change, making recommendations as it does across technology and training and plenty more. But really, our focus over the years has been on the waste in the system, which the arrangements post 2020 have generated. So I'm going to talk a bit about redaction, and I'll talk about some other stuff as well later on, third-party material, and also the dreaded IMD. So we've been gathering data to evidence the burden of redaction on policing, as of course the Federation have been doing, and the waste which in the system which is generated. We know that it's a real discouragement to investigators to submit cases for a charging decision, and it slows them down when they do. We've tried to rebut suggestions that technology is this panacea. Of course, technology helps, but the task of having to go through material is still there, even if that's technologically enabled. So yes, we've recommended better technology to forces elsewhere in the country, and those are being adopted. But technology really, as Ben understands, isn't the only answer, because it doesn't remove the waste from the system. So as I know, Ben and colleagues have been meeting with the most senior people we can. Most recently for me, that included the policing minister, the director of public prosecutions, the solicitor general. I'm doing so again in September. And there are certain work streams which we're looking at here. So first of all, technology. There is a national redaction working group, and we are exploring, this is all rather technical as you'd expect, but automated audio, visual and multimedia redaction tools of the sort which policing really should be using in the modern age. And we've got some early adopter forces from which we'll extract the best practice and hopefully roll those out rather faster with a national AVMM adoption pack, which sounds like the sort of thing you'd wear if you were an astronaut, but actually it's something rather less exciting than that. Then the next point is what are we doing in respect of what and when we redact? Well, we're again in an exercise which is looking at how we can collectively remove burdens from police and prosecutors. The CPS don't want all of this either. So this is looking at the bulk of redaction being undertaken post-charge by the police, the CPS, or a combination of the two. And the phrase of the moment really is streamlining disclosure. We understand how burdensome the rebuttable presumption system has come to be. We know why it came in the first place. It's because policing, to be frank, didn't distinguish ourselves in disclosure practice. We had a lot of cases collapsing at the doors of the court because we hadn't revealed material which really ought to have been revealed or disclosed. But the system as it stands is simply too burdensome. So we are, again, collecting some data in order to provide the strongest possible evidence base of what the problem is. I am somewhat frustrated in this respect because I feel we're having to evidence things to a degree which is plainly obvious, but nevertheless, where policy is concerned, that's what we're having to do. So we are looking at data to evidence the types of rebuttable presumption material which are meeting the test for disclosure, which we hope will help inform a new process. We've presented that work to the redaction senior sponsor group and made a couple of proposals. The first is that rebuttable presumption work moves post-charge. That prevents this awful waste in the system where officers and investigators are so demotivated by putting stuff in which ultimately proves to have been of no use. And the second is to amend the rebuttable presumption categories to reflect the types of material that are routinely meeting the test and are informed by the data. So that work is important. And I'm pleased to report we do have the ear and the support of the Attorney General and his office. They've agreed to look at a group to review and consider the changes which might relate to the guidelines, which I would contend were the source of the difficulties to begin with. But that's not all we've been doing. We've also been working hard to think about what other waste has been generated. So a few years ago, we introduced the investigation management document. That wasn't just because we had a kind of intent to make life very difficult for everyone. It's because in the wake of trials collapsing, such as Liam Allen, those in authority in the system had said, look, the police really need to get better at telling the CPS and the courts what they're doing and why in inquiries, and importantly what they're ruling out and why. That's why the IMD came in. It's a requirement of those guidelines. It's fair to say that might have been somewhat over-engineered. Perhaps it was too universally applicable. An IMD really needs to function as a diary rather than as a memoir to work properly, but people were completing it understandably at the end of cases rather than throughout, and it's just not functioning. So we have done an IMD survey. There's an exciting thing. We've had 1,300 responses, which we sent out, ably assisted by the brilliant Steph Tibbs, who works extremely hard on this. And a new version of the IMD is nearly complete, for which no doubt you'll be putting out the bunting, because it's reduced from 10 pages down to 3. No duplication of content, embedded guidance and screen tips, a quick tick not applicable function, tab formatting to remove the need to copy and paste, and new use case proposals to reduce the number of cases requiring an IMD. So that's good. Proposals to change the point at which it's done, and we're finalising some new supportive guidance. And we just think that's going to make completion of that essential document, which does inform the disclosure management process at court, that much easier, and that will be delivered under the auspices of a joint national board in which we're involved. So I do think colleagues will notice a difference there. And the other really important thing we've been working on is the third-party material request form. Disclosure really is about many things. It's about reasonable lines of inquiry. It's about following lines of inquiry, whether they implicate or eliminate a suspect. But it's also in recent years been about reconciling the absolute right to a fair trial of the suspect with the right to privacy of a victim. We've seen that in mobile phones where the victim sector would say, how can victims possibly get justice if you're going to carry out digital strip searches, where the legal sector would say you've got to do that if you want a right to a fair trial. And we've improved in that respect. The next frontier there was really third-party material. But the victim sector would say, why is it only in these sorts of cases where the police and the prosecuting authorities routinely inquire into a victim's educational, medical or social history to see if they've had a proclivity to lie in the past, for example, or if there's some inconsistency. Whereas, again, the legal sector might say, well, if you want a right to a fair trial, that's what you've got to do. It's a really challenging area because we want less disengagement from rape cases, but we also want fewer miscarriages of justice. So, again, we are in debt to operational colleagues for responding to the Federation. The new draft form of the third party in half the size. Again, embedded guidance, screen tips. This is all down to the self-effacing Steph, who really deserves a knighthood for all of this. Some better frequently asked questions, both for investigators, but also the third parties for whom we're requesting the information. We've enlisted some advice from data protection to do that rather better. Taken a little bit of time to finalise, but we need to make sure we got that right because there is an attendant legislative and code of practice framework, and we're working with the Home Office and other stakeholders on that. But that is going to free up a lot of time. It's going to make investigations a lot swifter. It's going to be a lot less burdensome on disclosure and on inquiries. We are pleased and proud with what we've done in that respect. So in summary, redaction, we're probably not looking at a legislative change given Parliament's interest in the timetable. We're doing some work on the technology. We think there are definite blue sky on the horizon in respect of what we can do to trim down disclosure at the pre-charge stage, because everyone's in favour of doing that. IMDs are going to be whittled right down, third-party material similarly so, and therefore the cause for optimism remains, and I think that's all I've got to say.
Very thorough stuff, Tim. Thank you very much indeed for that. In conclusion, yourself then, Ben, I know we've only got about 30 seconds. You heard Tim there talk about blue skies of optimism. Do you share that?
I do, and I do, once again, the work that Steph, Tim's staff officer on the portfolio does, and everyone else that contributes to it. My role will be to continue to liaise with Steph, to listen to what our members are saying, and to hold not only the NPCC but the government to account for delivering some real change in this to remove this burden on all our members and get better justice for victims.
Good work. We'll see where we are this time next year.
See you.
Good to see you again, Ben.
Thank you.
Ben Hudson, thank you to him, of course, and again, Chief Constable Tim de Meyer.